One second. Yeah. So, hello everyone and welcome. On behalf of IIT Alumni Association of Southern California, I'm delighted to have you join us today for an amazing webinar which is extremely relevant to our community, the future of H-1B immigration, what employers as well as professionals need to know. And so many people have joined us today on a Saturday morning, and it actually just shows how important this topic is to our community. For those who are new, the IIT Alumni Association of Southern California is a growing network of 3,000 plus professional alumni representing 23 IITs. Our events cover a variety of topics such as technology, investing, entrepreneurship, public policy, education, leadership, and more. Follow us on LinkedIn to stay updated on new events. And if you are an IITN in Southern California and you are not part of the WhatsApp group, please reach out to us. Now, um this before that, a little bit of house rules. So this session is being recorded and will be published on our YouTube channel. So please stay muted and please turn off your camera to reduce the distractions during the discussion. And please submit all of your questions in the Q&A section. We will address them in the end. Today's session is intended for educational and information purposes only. We'll be discussing trends, strategy, and planning consideration, but not providing legal advice. So if you have case-specific question, please consult directly with an immigration attorney. Now, with that, there's one thing that we wanted to put on a spotlight before we start the event. So this year in April, IIT alumni in USA are organizing an exciting conference in Long Beach, which is open to all. I would like to invite Lakshman Rao, who is the co-chair of IIT 2026, to share the exciting developments about the conference and introduce our speakers today. Lakshman is currently an engineering leader at Boeing. He has served as president of IIT SoCal for 5 years, converting this community into a driving force for laying the foundations to the strong community that we have right now. He is passionate about supporting the IITs as well as IIT alumni organizations. For his contribution, he also received the Distinguished Service Award from IIT Kharagpur in 2023. Lakshman, over to you.
Thank you very much, Dhanashree. Good morning, good afternoon, good evening to everyone from everybody you've joined. So I want to share about some really exciting, program that we have planned for the IIT 2026 Global Conference. So as the co-chairman, I want to invite you all and to visit our website, iit2026.org. So we have some amazing keynote speakers that are going to be speaking at the conference. We have four amazing tracks going from artificial intelligence to healthcare and sustainability, investments, and global connect. There are sessions on the other days where we have NVIDIA workshops going on. There is a golf tournament, so if you're a golf enthusiast, and some really stellar entertainment program that for the evenings. And of course, there is a lot to do with networking with your other ITians and non-ITians, of course. So it's a great, great event right here in Long Beach Convention Center. So please do join us for that. It's going to be really amazing. Um, so for today's event, as a promotion, we are offering a $50 discount for 10 people who sign up for the conference. So what we're going to do is, if you're interested in the conference, please do put your name in the chat. But we do need at least 10 people to say yes, and we will talk about that at the end of this event. So please do raise your hand and put your name in. We need at least 10 or more people for the discount to be available. We also have a student discount. So if you have students here, you can go to the website and see the discount student rate. All right, so I would like to now introduce our speakers and go over some house rules. Um, I'd like to introduce my dear friend Pramod Kunju. Pramod is a technology leader, entrepreneur, and AI strategist with more than 2 decades of experience driving data, analytics, and digital transformation. He's the founder and CEO of Nakunj Incorporated, a boutique AI and data consulting firm, and the author of AI in Criminal Justice. As co-chair of IIT 2026, Pramod works closely with global talent, startups, and enterprises, giving him a practical, employer-side perspective on immigration, workforce planning, and the intersection of policy and innovation. Today, he joins as a moderator, bringing both strategic clarity and real-world business insights to this conversation. Next, I'd like to introduce Jioselin Juarez Contreras. Thank you, Jioselin, for joining us to answer these immigration and really important questions. Jioselin is an immigration attorney and team lead at the Cerritos, California office of Chugh LLP. She earned her Juris Doctor from Western State College of Law and her undergraduate degree from University of California, Irvine. Her practice spans a wide range of employment-based immigration matters, including H-1B, L-1, O-1, permanent residency, EB-1, EB-2, EB-3, EB-5, I-140, and I-485 cases. She also has experience in removal, defense, and asylum representation before the Los Angeles and Van Nuys immigration courts. Jioselin is an active member of the American Immigration Lawyers Association, serving as AILA SoCal Secretary and bringing both technical expertise and frontline adjudication experience to today's discussion. All right, so a bit of house rules. This session is being recorded and will be published on our YouTube channel. Please stay muted during the discussion and submit your questions through the Q&A section. We will address them toward the end. Today's session is intended for educational and informational purposes. We will be discussing trends, strategy, and planning considerations, not providing individual legal advice. If you have case-specific questions, please consult directly with an immigration attorney. With that, over to you, Pramod.
Thank you, Lakshman. Thank you for that very generous introduction. I'll start by saying that it is an honor to share the virtual stage with Attorney Jioselin this morning. I also want to thank Priyank, Dhanasri, and the entire IIT SoCal team for putting together this very important and timely webinar. Now, I know that you're here to listen to Jioselin, so we're going to dive in there in a very short while. But before that, if I can ask Dhanasri to launch a quick poll. We want to know who is in the room so we can fine-tune our question answer session. Thank you for taking a few seconds or a minute to answer this very short poll. Yep. Well, looks like you have done this before. It's going up really fast.
We'll just wait for 5 more seconds and then we'll stop the poll. Yeah.
Okay,
Thank you.
I'm just going to use my IIT brain to process this because the multiple options are allowed and all the percentages don't add up to 100, which is okay. But I see that H-1B has won the poll today, followed by green card and then OPT. So yeah, we're going to cover all of those topics, but just wanted to make sure that we get a sense of who is in the room. So with that said, how we are going to do this is we are going to follow some type of a chronological order of someone coming to the US for higher studies on an F1 visa typically, and then moving on to secure an H-1B visa, and then hopefully opting to secure a permanent residency or a green card. So what we're going to do is start with a preset list of questions. You submitted some of them, and some of them are frequently asked questions. And then we will spend at least 30 minutes. That's our goal, to answer live questions from the audience. So get your questions ready. You can drop them on chat. We will be constantly monitoring the chat to make sure that we capture your questions. So with that, let's start with the student life, which is really represented by F1, OPT, STEM. There are different terminologies. So my first question to you, Jioselin, Attorney Jioselin, today is, can you tell us a little bit briefly about the differences between F1, OPT, STEM, and all those terminologies?
Yeah, thank you, Prama, for this question. So specifically, the differences between F1, OPT, and STEM is they're interrelated, but they're each individually separate. What I mean by this is F1 is the category that a person that would want to go to school for, be it certain, high school or something, but most commonly we see this more for the higher education. So of course, associates, bachelor's, a master's, PhD, doctorate degree, whatever it is. F1 is the actual category of the individual going to school, basically. So if you're outside the US, you would apply for this at a consulate or embassy abroad. You apply, and then if you're approved, you come in with that status, basically. If you're here and you have the opportunity to become an F1, then of course you would have that category and attend school. Now, OPT and STEM OPT are basically benefits deriving from F1. OPT is optical practical training. Basically, either during a program or after your program, you're able to apply for either for 12 months after graduation, and then during school you could apply for OPT as well. And it doesn't have to be related to your degree, whatever the degree it is that you're pursuing. And then for STEM OPT, it's basically what it's considered, one of the STEM fields. Basically, you get an additional on top of the 12 months you originally get after graduating, you get 24 months. So basically, if you're in a degree that qualifies for STEM, you would get the 12 months and then the 24 months. So up to 3 years, basically. And again, it has to be, depending on your degree for STEM, and then you would have to apply both for OPT and STEP OPT with your school directly. You apply with your designated school official. So you should, communicate that with them on that. There are specific timelines on everything for that, and we'll get more into it as we go through.
Okay, thank you. I think I'm going to reserve all my thank yous into one at the very end. Okay, so related to F1 students, can an F1 student pursue a paid summer internship?
It depends. So I'll be using that word a lot throughout our conversation just because of the situation of the program, right? So basically it is a possibility, but of course, if you're on F1, you automatically don't, that doesn't allow for work unless you apply with your designated school official. They have to basically approve it. There's two basically ways that you could consider to do a summer internship. One is through curriculum practical training. So that basically is called CPT. That's the acronym that you would normally get. When you're pursuing a degree, if the degree, is able to need basically a specific kind of training basically for your degree, you could apply with your DSO, which is a designated school official, to get that summer internship. Of course, your training under that summer internship does have to be related to your degree pursuing. And then, of course, your DSO has to approve it. So you can't start working, of course, until it gets approved. And then second way around it is as well, if you are able to apply for OPT either during your actual degree, and then it could be on campus. But the thing with OPT, a little bit of differentiation on CPT. A person is able to apply for the summer internship based on CPT and start as soon as their DSO approves. However, on OPT, they do have to wait for the actual EAD, employment authorization document, to start working. So there's, pros and cons on that. And that's a discussion, again, the individual can discuss with their DSO.
Okay, great. Let's say that a student graduates from the program, whether undergrad or master's, but does not have a job offer. How long can they remain in the US without having employment?
So Basically, just to give you a little, so I think a little bit of background for this question will be important. So, basically, before you graduate, if you're going to apply for, if you want to look for a job, right, or work, basically, sorry, work for somebody, whatever company it is, right, you do have to basically apply a certain amount of time before you graduate for OPT. That's what you're looking at. At that point, you don't need, you could be looking for employers on what you want to do. But if you don't have a concrete job offer, you could not work if that's what you choose to do. And of course, you have the 60-day grace period. But if for some reason you did get approved for the OPT and something happened with that position, you do get the unemployment basically period to look for a position. For OPT, you get the allocated 90 days of unemployment. You can, of course, not go beyond that. But if if you have no job offer, something changes, then you do have the 90 days to look for the position. Of course, as long as the OPT has been approved.
Okay, great. Now, something that we don't want to see happen, but happens quite a bit, which is, or more than we like to see, which is someone losing their job while on OPT. How quickly should they find another position to remain in status?
Yeah, so just like I mentioned, they have up to 90 days. And then, of course, if that candidate or student has the ability to do STEM, one of the things a lot of them may not know, which is, looking at the regulations and the law, is if you do have, for example, PT, you didn't use up all your 90 days, and then you go on STEM, and then something happens during the STEM OPT, you could allocate those. If you took 60 individually on the OPT, but you have 30 remaining, that transfers over to the STEM OPT. For STEM OPT, you only get 60. So 90, 60, that means 150. If you only used 100 for, 30 on the first one, you get the leftover for the STEM OPT. So that's a benefit, which basically it's really recommended that you keep track of the amount of days you were unemployed, because you don't want to go over the maximum allotted time.
Okay. Let's say that an employer pushes a new hire start date back, again in the context of a student visa and OPT and so on. Does the delay count against the individual's allocated time?
Usually it will, because of course, if that employer is confirming that you're going to start on a specific date and you're not, I mean, that's not, no, there's no productive work being allocated. The good thing is on OPT, there's flexibility to have multiple part-time jobs. So I think at that point, a good conversation, if there's not a certain expectation of how far the push of the start date is going to be, would be a discussion with the DSO to potentially have a change or conversation of what are your options, because you could be on part-time OPT for multiple employers when you are OPT. So that's specifically it. Now for STEM, I just kind of want to add STEM's a little bit different. So that would be a really consideration to confirm with your DSO, because for STEM, you do have to be full-time, and that gets a little bit tricky when you have the ability to do multiple part-time for OPT, but STEM is very specific, and there's more requirements for STEM OPT. So specifically, you just want to make sure you're following the right procedures for each process individually.
Okay. Again, if you have questions or this conversation triggers a question for you, please drop that on the chat. We are constantly monitoring it, and we'll address that during the live Q&A. Okay, next question. Can contract or part-time work qualify as valid employment while on OPT or STEM?
Yeah, so on OPT, yes, you can do contract work. You don't have to be, I know most of the public, if not, they don't know. You don't have to be a W-2 employee. You could be a contractor. You could be part-time on OPTs. That's totally viable. Of course, the main thing is that the employment that you are doing, be it whatever form, it is related to your degree, because that's, the reason for the optical practical training is so that it benefits your experience, your furtherance in your degree, of course. And then, of course, you're going to have to make sure you follow all these documentation you submitted to your DSO. If it's, the number of duties, wherever you're going to work, who's going to supervise you, whatever it is, you're following that for the OPT. For the STEM is a little bit different, because STEM does have the requirement specifically that the company that's going to sponsor you for the STEM OPT is, first of all, e-verified, that they are your employer, that you are full-time. So there's specific requirements for that because of that thing. It's not as easily of a process as the OPT for like contract part-time work. So you just want to verify with your DSO. The DSO is the best point of contact, specifically from your school. You should be very well versed who your DSO is for that. Just because, you know, of course, you're going to update all this information about whether you're full part-time or contract work, whatever it is, on your I-20s. I know I haven't mentioned that, but that's for any student. You always want to make sure any of these changes, any of these employments are updated and reflected of your I-20. It's very vital.
Okay, looks like the DSO has a pretty important role, and hopefully the ratio of a DSO to students is not overwhelming. Okay, so the next question, if someone takes an unpaid position related to the degree, as you mentioned, does that protect their status?
Yeah, so as long as the position is basically related to your degree and basically if it's on your I-20, that means it was approved, basically. Because, you know, like I said, the I-20 will not get issued unless all these requirements are met. So if the position relates, you know, they get all the job duties, everything of what you're going to be doing, that should be fine. Of course, if there's any change, then you want to make sure that gets reflected so that there's no issue on your status. You always want to make sure that all data that's reflected on the I-24 is accurate, because that will, you know, again, protect your status, and that will protect your SEVIS. The SEVIS record is on the I-20. That's what the record basically reflects for a student, that they have an active F1 status.
Okay, great. Let's say an individual reaches the end of OPT with no sponsorship. Do they need to leave the country immediately, or what happens to their status?
Yeah, so if for some reason, you know, something happens, OPT doesn't work out, you know, you get the traditional, you know, 60-day grace, again, you know, to depart, transfer, change, whatever it is. You know, with the current, for the current, you know, trends of what immigration is right now, you know, the 60 degrees, you want to do it as soon as possible, just to not jeopardize any future options. Of course, you don't want to stay beyond the allocated time of, you know, that would activate any unlawful presence. So, but you get the traditional 60 days grace.
Okay. Just a couple more questions on the F1 OPT front. If someone enrolls in another degree program, can they remain in the US without any interruption?
Yeah, so it's, you know, it's very common that a lot of students, once they, you know, complete their bachelor's, master's, whatever it is, or their certification program, they want to continue their studies. You know, a lot of opportunities here for specific specializations, whatever. So as long as they apply to the school, whatever the procedures are, and they get the issued, again, Form I-20, reflects their new program, whatever the date of that the program will start, that's totally fine. That's totally fine. And if there's always the popular question of what happens, because it's like I applied for the fall and I'm in the summer. Like, does that mean like I have to leave, come back? Basically, as long as if you're enrolled on the next coming term, that is totally fine. So that means if you applied, that's totally fine. And if the thing is, if you travel, it just, you know, there's some complications on that, you know, I don't want to confuse anybody, but you just want to make sure that any kind of travel, if you are traveling, you want to confirm that with your DSO for permission, because you would require that, and visa issuance, that you actually have a visa to return. So you always want to confirm all these things with, you know, either your DSO, or you could also speak to an immigration attorney, either myself or anybody that you trust.
Okay, great. So last question in this category. It's a little bit subjective, but let's say that someone unintentionally stays beyond their allocated time on OPT, then what happens?
Yeah, that's a sensitive question for sure. So just to kind of the breakdown, the main thing that anybody that, you know, for some reason falls out of status, the best thing they want to do is you know, leave as soon as possible. I understand life happens, things happen, you have, you know, apartments, stuff to take affairs. We totally understand that. But there is in the regulations for immigration that when you stay beyond unlawful presence, beyond 180 days, you trigger, once you stay more than 180 days and then you leave, you trigger a 3-year bar basically. And then if you stay more than a year, then you trigger a 10-year bar. So the thing is, you never want to stay, really, the longer is the worse basically. So you want to make sure to take care of your affairs, plan this very closely, get a opinion from and advice from an attorney to make sure you're doing everything in the correct way. But there are consequences if you stay beyond a certain amount of days, for sure.
Okay, that takes us to the end of the first category, which is the student visas and OPT. Now, again, if you have any other questions related to that, please drop them in chat and we will get to those after the fireside chat. Okay, so let's move on to H-1B. Let's say an applicant is not selected in the H-1B lottery. Can they remain in the US and try again the next year?
So they can if they have another status currently. So they just can't be here unless because they so choose, because then they're here without status. But if they're on a student visa, for example, we just spoke about F1 student visa, and they're still finishing up their program, they have still time. Yes, that's fine. If they're on OPT and they still have their STEM OPT to extend, totally fine as well. That's the main thing. You want to make sure you continue maintaining whatever you currently have until the next round of lottery, and hopefully you get selected.
Okay. This may be related to the previous question in some fashion, but let's say an employer offers sponsorship in the future, but not currently or immediately. What risk does this create for the employee?
Yeah, I mean, you touched up on, you understood it, Pramod. So yeah, it relates to the previous question, which is if your employer doesn't, and this could be for, H-1B sponsorship or whatever sponsorship, it just means that you have to maintain your underlying status until they decide to proceed with another option. You want to make sure you're continuing to maintain your status. So if you're a student, you continue going to school. If you're OPT, you're employed in a position that is approved by your school DSO officials. So all of that's being followed. If you're like a dependent status, that your main spouse is continuing their status, so you're still a derivative on their status. So all that will basically, you have to make sure you're following for sure.
Okay, great. Next question for you, Jioselin. Let's say an H-1B petition is selected, I believe, during the lottery process, but later denied. Does the individual lose their ability to stay in the US at that point?
So I think all these are interrelated. So these are great questions, but it's the maintenance of their underlying status. So just basically making sure that they continue to extend, continue going to school, whatever it is that their underlying status requires them to do, they continue that. Now, the one thing I want to mention is, of course, I'm hoping that, that your H-1 was filed by an attorney. There are options to try to, appeal the decision if it's appealable. And then if that gets if it's able to be appealed, sorry. If that is overcome, then of course you would get that approved. But that is an option you want to explore before, denials could potentially be overcome if there's a good argument to make.
Okay. Again, if you joined recently, you can drop additional questions on chat and we'll get to those after this set of questions that we are going through right now. Okay, next question. Can someone change employers while waiting for an approved H-1B to take effect?
So it's like a two-part question to this. So if, for example, I see this very frequently, if a person is on an OPT or STEM, you're allowed to change employers within the OPT and STEM. You just have to get them approved, and that's totally fine. Because the H-1B is not going to kick in, of course, until it's approved. So you could still change employers if your underlying status allows for the change of employers. If the H-1B is if it's not, sorry, if it's, you could change your employers if you're OPT or STEM and you're waiting for a cap. But if you're waiting for a decision on a non-cap case, then you would just do a transfer, and yeah, you could change employers and start employment actually with the new employer. But of course, there are things to consider separately on that. But it kind of depends on which kind of situation the individual is in. But there are options, yes.
Okay, great. Let's say an H-1B visa status expires and it's not renewed. or in an unfortunate event, an individual is subjected to a layoff, how much time does that person have before they must leave the country, or what is the remediation?
Yeah, so I think I'll answer the middle part that you asked. So the layoff part, I know a lot of information is out there on something that you consider the grace period, which is 60 days grace period. Traditionally, I'm gonna say traditionally because there's been a couple changes during the last about a year. If you lost your job, if you were terminated, you could find a new employer, and within the 60 days you could do the change to the new employer, and then once approved you could start with that employer. Traditionally there's been a few changes. The 60 days grace has never been guaranteed even before the changes, but now it's a discretion to the officers. Now is very much more discretionary now, so 60 days might not be a viable option at times, depending on the officer. But that's a possibility, possibly, basically. If it expires and it's not renewed, then that's a completely different conversation, because that means you are, and to a certain extent, out of status, right? You didn't renew, you expired without basically renewing, basically. At that point, the consideration is two things. You could either, have the 60 days to leave if you decide to do that. There is a possibility if the expiration or renewal was something that was outside of your control. That's called no per tongue. It's a request to discretion to USCIS if something happened. If you had a specific illness, something happened, you were literally outside of your control, nothing you could do to renew it, you might be able to have that case be heard by USCIS. But again, these two options individually of termination or not renewing or expiring, it's discretionary. So again, it's not guaranteed, but those are options that you could explore with the attorney who's assisting you with.
Okay, great. So next question is about people who want to start a business or work for their own company. By the way, if you intend to do either of those, you should definitely check out IIT 2026. That's coming up in Long Beach in April. I know Lakshman has been aggressively promoting that on chat, and you'll gain a lot of tips at the conference if you choose to do that. But the question here is, can someone on H-1B do either of those?
Yeah, so that's actually a very popular question I get now. The nature of it, the ability. We all know the US is a great place where you could go and start a business from the ground up and build, and that's a dream for a lot of people, right? But yeah, it is the viability, but of course, it's a very specific process. More often than not, it depends if you want to be involved in the business. Because if you want to be a passive investor, that's a completely different conversation. But if you want to be an active investor and you already have gotten an H-1B visa allocated to you, then we would be potentially discussing individually how the setup of the company is going to be, the percentage of ownership, because the H-1B does require an employee and employer relationship. And in a way, you're going to be involved in the management side of it. We do have to have those conversations to figure out. But the kind of process that you would be looking at is the H-1B entrepreneur. Of course, the position that you're going to do for that business, if you're going to be an investor actively working in the business, is that, of course, it has to be a specialty occupation. So that means, of course, the position has to qualify, and you have to have the proper degree for that position individually. But it is an option, and there's things to consider specifically. There was a change recently with the H-1B modernization rule, where there was a few changes on what USCIS would be looking at for the H-1B entrepreneur. So that's something you want to make sure that you're very well versed speaking with a professional, an immigration professional, an attorney, so that they could walk you through how that looks now on an H-1B entrepreneur process.
Okay, thank you for the very detailed response. I know many H-1B people on H-1B are interested in launching their own companies. Okay, so with so much bad press, certainly recently about H-1B, what are some of the alternatives? You hear things about O1, L1, B1. Could you talk a little bit about any of those?
Yeah, I mean, that's a lot of when my profile was shared, you guys heard, I do everything basically. So with anybody that I work with, we always explore all these options. We look at their background, we look where they want to So it's kind of a three-parter where they're at in their career, what are their goals, and what is their end goal, basically, right? Pressing goal and then end goal, right? O1 is very, H1 and O1 are very different. H1, specialty occupation in the position that qualifies. You have an employer-employee relationship, or you're going to start your own business, right? O1 is very specific criteria as extraordinary ability, either in the science or other fields as well. And there's an O1B, O1A, right? You have to meet three of the criteria. They're very discretionary. So it really depends on the profile of the applicant, if they've been published, recognized, awarded, various things that we could discuss. And that could be a whole separate conversation individually. But L1 as well, if you were employed abroad in a company that's related, we have to look at the timeline of when your employment was, but that is also a good option as well. And then B1's a little bit tricky though, because B1, it does not really a long-term solution. And the thing with B1, it's very limited activities. It doesn't allow for actual employment with the US company. That's why it's usually not the best course of action. You want to kind of have a really detailed conversation with an immigration attorney discussing the other really temporary work options that will allow you to, work here for a longer duration, will allow you to work at for sure, but also have a long-term goal of, setting you up to potential other options in the future for permanent residency as well. There's also other options, for individuals from certain countries, nationals of certain countries. There's like E2 if you're from certain treaty countries, for if you're trying to invest here in the US. So if you have citizenship from certain countries, TNs are for professionals in Canada and Mexico. So there's other options for sure. And you want to make sure that you speak with an attorney that knows all these options so that you could make sure that you have a comprehensive review of all your options.
Okay, great. Well, the next question, I think the answer almost depends on the day of the week or the month of the year. But the question is the latest guidelines for spouses on H4 visa being able to secure employment.
Yeah, so that's a very popular question on a day-to-day basis, and probably that this question might have been more on a lot of people's radar from last year because of the change on the automatic extension for H4 EDs. The first thing I want to clarify for the public on this webinar is, first of all, H4 doesn't automatically allow you to work. Your principal spouse, and I say the one that has the H-1B, has to either basically be have an I-140 approved or be a C-21. There's two specific criteria basically to then for the H-4 applicant to apply for an EAD. You're able to be here lawfully under H-4 until they don't have either of those two options. And then once they do, then you could apply for EAD. And once you do, basically, you apply for the EAD, you have to wait for the EAD to be issued if it's your first time. Previously, if you were going to do a renewal, you could get the automatic extension, but there was a change last year with the automatic extension for H-4EDs. So that means now that it's more important than ever to apply with amp time. You are able to do it, the 6 months in advance before then. But of course, there's also the added change as well that, before, if you bundled cases H4 with H4 premium cases, H-1B premium cases with H4 and H-4D, it would technically be approved somewhere at the same time. But now we don't fully, I don't fully know what the trend is on that one because, there's been a few changes on that. But I mean, the best thing that anybody wants to do if they're able to apply for H-4ED is to apply early as they can.
Okay, great. So the last question related to H visas is a little bit of a speculative question, but also important. There's a lot of talk about bills being proposed in Congress to eliminate H-1B almost. So what do you think about the future of this type of a visa category?
It's a daily question from every single person we know. And like I said, you mentioned in my bio, I'm part of the Immigration Lawyers Association in Southern California. So we always get those questions. So what's going to happen? How do you predict? I wish I had a crystal ball because that would make me very happy with my clients, but I don't. So the thing with the proposals, the first thing I think anybody has to understand is that a proposed bill has to go through a specific process. So it has to go through two parts of the Congress. So basically, it goes through the House of Representatives and the Senate individually, whatever way it's introduced. The main thing that you would want to make sure you do is that you speak to your congressional representatives, let them know what the effect is of these bills if they are to pass. I mean, they really don't know what the effect of these bills are unless you speak up. So that would be the first course of action. And also inform basically your community basically about, a lot of people don't know what the H-1B program is, right? So they don't fully understand that, these are added benefits to the US economy, added benefit to community in general, right? For the prosperity of America. So I think that would be the best course of action. You always have a right to, speak up in regards to peacefully speak to your representative, process whatever it is that you do. But I mean, reality of it, there's a lot of bills out there, but nothing has been concrete. A lot of the changes people don't understand it's been policy updates. It hasn't been actual. The only one that's been an actual bill was the H-1B modernization rule. And the big beautiful bill that passed because that one had some added increases of fees. Those were the ones but everything else like specialty occupation terms haven't changed. So you just want to be well versed on what it is that's changing, if it's policy or a bill, but really important for you to maintain information updates and speak to your congressional representatives.
Okay, thank you, Attorney Jioselin. That's great advice. So that brings us to the end of questions related to H-1 visa. And again, if you have additional questions, please drop them on chat. We are monitoring the chat constantly, and we'll try to get to as many as possible during live Q&A. Okay, moving on to green card or permanent residency. The first question, can an employee change jobs while a green card application is in progress?
Great question. So I like I said earlier, it depends, right? It depends where you're at on your stage of your green card. So green card, because some individuals use the term green card to think about like the first part of the process, which is like if you're doing a labor certification process, they consider it. If you're like very early on your process, like labor certification, that's a different discussion, right? Or perm pending, something like that. But if you have a green card application actually already filed, which is the I-45 application already filed, and it's already pending for more than 180 days, then there's something called the AC-21 job portability, which is if you get a new job offer from a different employer that did not do your green card process and the position is in the same or similar occupation, then yes, that is a viability. But again, it's very hard to predict for any individual case. So you would have to make sure to speak to an immigration attorney professional to discuss if your specific example of case would allow for that to not affect your green card process, basically. Just because there's specific timeline that you want to consider, because sometimes you may not be able to, but sometimes you may be able to.
Okay, great. So next question, this can be confusing. Can an individual accept a promotion or role change while waiting for permanent residency?
Yeah, that's a tricky one because like I just said, same or similar position, right? If your green card application is pending, it's a certain position, but this is completely different, then we have to kind of, you kind of have to think if the position that you normally would have done is still available, right? You don't want to have that confusion with USCIS, that position is no longer available because it has to be a job for that's available. So that's something to consider. If the position is the promotion is not completely different, like it's a small change, like an additional few duties, but like the core of the position is still intact, then that should technically be fine. But again, it's the evaluation of the same or similar position. That's what I would consider.
Okay. We have a question similar to what was covered during the H1 category, which is alternate options for green card. For example, we have heard about Canadian PR, or what else can you think of?
Yeah, I mean, the good thing, is there's a lot of options out there. I think the best, thought process that when I speak to any potential candidate or client is that I really make sure to understand their life perspective, what their end goal is. If their end goal is, if they think that it might not work in the US, then, exploring other options is not a bad thing to set up your profile for maybe, when you're ready to have your profile set up, come back to the US. There's certain things, for example, I know we're talking to IIT Alumni Association of SoCal members. A lot of you may be from descendants from India, right? I know the whole backlog, priority date, visa bulletin. A lot of what I've been seeing recently is individuals going to other countries that able to have a pathway to, citizenship or permanent residency. For example, Canada is very, it's up north, very popular. And if you do get a Canadian citizenship after a certain amount of time, you are able to, for example, to apply for an E2 visa. I briefly went over it before. I know not in detail, but E2 is like an investor visa. Basically, you want to start a business here for a certain amount of money, and you're able to build your business here. That's an option, but of course that would involve having to go back elsewhere and then building your profile. But there's options, and the good thing is across the board. Within our office, we actually do kind of those cases as well, like for other countries as well. So we really, you really want to make sure that you're really exploring all your options because it's really important.
Okay, great. Well, these days you cannot end a webinar without asking a question related to AI. So what about all the tools like ChatGPT? Is it okay to get immigration advice from ChatGPT or your favorite AI tool like Gemini?
Oh my God, yeah, that's I mean, you probably the public would probably think, there's no way she's gonna say like a ChatGPT is useful. I mean, the first thing you guys, if you've used ChatGPT Gemini, is that it has a disclaimer that it's not, it could be wrong, right? And you do not want to jeopardize your immigration status on getting wrong information. That's a no-no. Like you don't want to do that. There's consequences for immigration is very severe if it goes wrong. You want to make sure you're strategizing your immigration process in the right way with the right professional, and that you're not, it's not a form filling process, which a lot of people think it is. Every box that you check is very vital. It could have consequences. So you want to make sure if you want to get a list of like checklists to help put together with your attorney, if you want to, spell check stuff, awesome. But if you want to strategize a process, so I think that's very tricky, something that might involve a specific, waiver or specific like sub elements, you don't want to risk that. So you want to be very cautious about it, and be open-minded, of course, that technology is there, but also make sure you talk to an actual immigration attorney at the end of the day.
Okay, so essentially keep a human in the loop. That makes sense. Well, thank you, Attorney Jioselin. That brings us to the end of all the curated questions, and we'll be switching over to live Q&A shortly. So please, if you have other questions, please drop them on chat. And I'll soon bring Lakshman back on screen. But before that, I want to leave you with a little bit of a thought because most of us came through this immigration process. I came here many years ago on H1, and I remember the days when I would be getting up in the morning and looking at some website. I don't remember what it was, but checking the priority days, whether it's moving and all the stress associated with that. So we have been there and we are here to help if any of you needs it. And I would also say that it's not a sign of weakness to ask for help, just the other way around. So yeah, please reach out if you need anything. Thank you. Lakshman, the floor is yours.
Thank you, Pramod, and thank you, Jocelyn. Really great, session, Q&A session, and really, really appreciate all the information you shared. Yeah, I can say from my own experience, it has been, yeah, a lot of the things were quite challenging, going through the F1, the H1, and then the green card process. So everyone has their own experience and the story to tell. So things just seem to be getting harder and harder. So I really, appreciate all the information that has been shared to keep us up to date. With that, I would like to introduce Ariana Gonzalez. Ariana is a business development leader at Chugh LLP, a full-service law and CPA firm with offices across the United States and India. She focuses on strategic growth, client engagement, and cross-border relationships, particularly within the immigration and international business space. Ariana works closely with attorneys, CPAs, and firm leadership to expand market presence, strengthen corporate partnerships, and deliver educational programs that inform and empower clients. She is passionate about connecting people, building long-term relationships, and helping businesses navigate complex legal and financial matters with clarity and confidence. Ariana, I'll pass the ball over to you.
Thank you, Lakshman. So I am going to go ahead and ask all of your questions. So feel free to reach out if you guys have any additional questions, put them in the comments. I also did share Jioselin's email if any of you want to personally reach out. So Jioselin, first question, if a candidate on an active H-1 status with employee A accepts another offer from company B who has initiated the H-1 transfer process, candidate starts working for company B and then they get a rejection on the transfer to company B. Is the candidate on or out of status?
Oh, wow. Okay, so that's a very concrete question. There's certain options that, just keywords. It's gonna be a little bit difficult for me to respond this one. I would prefer that the person reaches out to me. But what I could say is this, just keywords of what H-1B is, right? So you're able to do, transfers from one position to another. As long as you're still in status, you could do the transfer, right? Once the H-1B transfer is pending, it's usually recommended now that the person doesn't start right away because of the whole 100K. I know we probably didn't spend a lot of time on the 100K proclamation, but because of that, usually recommendation is that you start working once you get that approved. And this individual that asked the question says the candidate starts working for a company and they get a rejection on the transfer as a candidate out of status. Okay, so it would depend basically, if I'm hoping I get all the information correct, but if the individual is still employed with company A, they're okay. But if they are not employed and they're out of status, then that would be a discussion to see what's a viable option, to see if potentially they could still remain here or not. So again, it's very concrete. It's a very sensitive question. So I would say that reaching out to an actual immigration attorney to look at all your documents is a little bit hard to gauge if I'm getting all the information would be the best course of action. But I'm sorry, I can't fully answer that question.
Oh, no worries. Sometimes we do get those questions. So yeah, feel free to reach out if your question can't fully be answered on the live. So can a candidate start their own business with which they can sponsor their visa?
Yeah, so that was one of the questions that we discussed early, where if they're talking about H-1B specifically, you could be an entrepreneur. Yes, there's certain things like I mentioned when Pranav asked me this question that you would need to meet specifically, and not just H-1. There's also O-1 as well. Of course, you have to meet the actual requirements themselves. Aside from that, but there's also an ability to start your own business on O-1. A lot of startups founders are probably looking at those options if they're of course not born here or naturalized here. So there are options to start your own business if that is what you choose to do.
Okay, thank you. And what is the recommended pathway for folks with academic CAP exempt H-1B status to transition to industry roles?
Yeah, so if you're on a CAP exempt, because I think you said CAP academic, right? Academic H-1B, right? Sorry.
Correct. Academic/CAP exempt H-1B.
Okay, transition. Okay, so you're basically, it's a great question. So if you're on an H-1B CAP exempt, and you haven't gone through the lottery, we went briefly through those questions. You have to maintain a employment with a CAP exempt. It could be with a higher institution of higher education, or certain affiliates with higher institutions, but you have to maintain an employment. You could progress with other occupations, but if you of course don't continue employment with a CAP exempt, then you would have to be subject to the CAP lottery. And if you do go through the CAP lottery and you continue, you could do a CAP exempt employment and a CAP subject employment. That's totally fine. And you could do vice versa, basically. You could be cap exempt and be non-cap subject. It's just as soon as you lose a cap exempt and you haven't done cap, then you are kind of in a very tough situation, basically. But yeah, building your profile is a possible as long as you can do it in the correct way.
Okay, great. And if a current student has their future employer apply for H-1B, will that be, it says 0th attempt and they will have 3 more years, F1 OPT plus 2 years, STEM OPT, hence 4 attempts in total in this case?
Okay, that's an actually popular question, doing the math.
Okay.
So it's a fun joke because attorneys don't do math, but I got this one. Okay, so basically, if you're a student and you, for example, just so I'll do. I think I got their question or his question or her question. So if you're currently about to graduate, because we're in February, right? A lot of students are about to graduate in May, June, and you're able to apply for your OPT for the next 12 months, right? So you're gonna get, you could do cap, you can't do, well, not backtrack that. You may be able to do cap this year, depending on when you get your degree. That's the main thing. So if you already have a bachelor's, you're fine. But if you don't, then you have to see if you're going to be able to get your bachelor's because you need 8 bachelors if you don't have one from abroad. Okay. If you don't have one from abroad, this is your first bachelor's year, then you have to kind of see if you're able to get your degree on time for the actual H-1B cap petition if you are selected. So if you're able to do it this year, that would be one. If you don't get selected, then you get, next year, depending on when your OPT expires, so you get 2. And then if you have STEM, then you would get the following and the following. So in a way, you just have to see expiration, but there is a viability that you may have up to 4 for options because you have 4 years basically of doing cap. So it depends just based on your expiration on your authorizations.
Perfect. And I'm not sure if we've answered this one yet, but I do see it collected beforehand. Is it difficult for master students to get the EB1? How should they develop their profile?
Great question. So it's not impossible to do EB1 if you're a master's. It really depends on your profile. The biggest thing that you want to kind of look at if you're a candidate that wants to potentially do EB1 is look at the USCIS policy manual for EB1A. It tells you actually specifically talk to an attorney as well to kind of if you have any questions on the policy manual. But it does say examples of what evidence officers are looking at when they're adjudicated. But of course, certain things you also have to consider as you put the evidence together. So it depends on the industry. It's very hard to give specific piece of a recommendation because certain occupations, they don't have the same type of evidence for EB5. If we're talking about an artist, it's very different. They don't publish, they kind of advertise their work. But if you're talking about a tech person, they may have publications, they might have recommendations, all of that. So it varies. So the biggest thing is I do a lot of, we do here at Chugh, we do EB1s, O1s. So I have those conversations individually for each candidate to see where they're at. But it's possible, but case by case.
Perfect. And then do EB1A and EB1B have different waiting periods at present? Can our employer file EB1A?
Okay, perfect. So I think I saw that question early on. So EB1A and EB1B is the same category on the visa bulletin. If that's the question of the person that asked that question, it's only when it's EB2 and EB3 and EB4 and EB5, they have different categories. And then of course, that depending of your nationality, then you're going to look at the specific section in the visa bulletin. No difference between EB1 and EB1 and EB1A and EB1B, sorry.
Yeah.
But in regards to EB1A does not require a job offer, specifically because I think that was part of the question, which is, does your employer need to? They don't need to. You could actually apply yourself. If they want to provide any supporting evidence, they could do that as well. But it's not a requirement that they do EB1A. That's really a conversation between the candidate and the employer if they want to come to an agreement on that process specifically, but actually it's not a requirement that they are required to sponsor them for the job, no, for the EB1.
Okay, perfect. And then I see another question here. Is payroll necessary to prove STEM OPT employment when working as a founder on my LLC company? My company is enrolled in E-Verify program and my training plan includes a board member as supervisory authority. this training plan is approved by DSO. Is there an added scrutiny for people with F1 OPT who have maxed out their STEM OPT range to, oh, sorry, that's a different question.
Okay.
Let me go ahead and repeat the first one. They were right
Okay.
after each other. I think it's from the same person. So, is payroll necessary to prove STEM OPT employment when working as a founder on my LLC company? My company is enrolled in E-Verify program, and my training plan includes a board member as supervisory authority. The training plan is approved by DSO.
Okay. But great to hear that they were approved by the DSO. That's the first thing I would want to confirm with them. Just because STEM OPT does have the requirement, that's why you had probably the board member employee relationship for the STEM OPT. So that's good, and they're E-Verified, great. I mean, it would be highly recommended that you have the documentation that you fulfilled all the requirements that you put on your 983 training program, specifically whatever the salary that was going to be paid in whatever manner. I don't know the nuances of what documentation was submitted for that person. But the biggest thing is if you ultimately change your status to something else, they may want proof of your maintenance of status fulfilling the conditions on the current status. And if there is no evidence, then they could call into question whether you properly maintained. So you just want to make sure you're cautious about that, whoever asked that question. It's better to have the documentation in place so that there's no call into question on the maintenance. That would be the best thing you want to consider.
Okay, great. And then another question from Mohan. Is there an added scrutiny for people with F1 OPT who have maxed out their STEM OPT range to go for day one CPT degree?
Yeah, that's actually been a very popular question for years, not even recently, for years. There's been, a disconnect and no true clarification from USCIS on that point. A few years back, there was a lot of discussion back and forth of whether they consider. So the thing with the OPT and the STEM is they have a language on the regulation saying that, once you use up they say like a level of education that you're proceeding on your education. Now, if your degree is master's and then you go day one CPT with something else, education my level is absolutely fine. But if you're on a master, there is a very viable possibility that they could, question or scrutinize because you're at a same level of education applying for day one CPT. There is a possibility that can happen. So what that normally looks like is that it's issued on an RFE. And what they want to see is the necessity or the need for day one CPT. So that's a conversation you would need to have with your school to see if they have documentation in place to see why they approve day one CPT in the program, so that there is no issue on the status situation. So just have that conversation with your school to make sure that they have all the documentation in place to say that day one CPT is necessary.
Wonderful insights. Thank you. We have one more question here. If you guys have questions that come up later, feel free to reach out to Jioselin. We're always happy to help out. So if a current student can receive their US degree only after 25th June, and if they get selected in the lottery but not able to submit the degree for filing, will the H-1B selection be affected? And can I still apply for the $65,000 regular cap slots? I already have a bachelor's degree. My master's degree is in the US.
Oh my God, it's a very I always get a bundle of cases every year like that. It's always a timeline. So it depends basically. So there's two options basically. One, because the person said they have a bachelor's abroad, you could just file under the bachelor's, then you would just be under the traditional 65. That's I want to say the conservative approach basically. However, if you're currently applying for a US master that qualifies in an institution for the master's cap basically, you would have to see when it actually is conferred, the degree is conferred basically. Sometimes the schools take like an extra 1 to 2 months to mail you your degree, and then by that time you would be post June 30th. So if that happens, then it is still possible to argue that it was conferred before the 30th deadline, which is the last day for cap petition if you get selected. However, it was an issue, so then at that point you could either supplement if you file your petition thereafter once you get your degree, or you would wait for the RFE to be issued because they would need a copy of the degree to do that. So it depends. That's a very strategy with the employer and then the employee if they're brought in to have that conversation. But it's possible, but it's a very detailed conversation that you would need to have from all parties.
Perfect. Thank you so much, Jioselin. I think that's all the questions we have so far. So as I mentioned, if anything comes up, feel free to reach out to us. We don't only do immigration, we do corporate, litigation, tax, accounting. As Lakshman mentioned, we have offices in India as well. So if you have a business here or in India, if you need any assistance with that, feel free to reach out to us. If you just need help with your taxes, we do individuals, small businesses, medium and large. So we help everybody for every service we offer. So feel free to reach out if you guys have any questions or comments. We do also do a weekly live stream on Thursdays on a different topic each week. So if there's a topic you want us to cover that we haven't already covered, feel free to reach out to us. And we're always taking suggestions on new topics to cover so this conversation can continue. Yeah, thank you. It looks like we had another question pop up. So how easy or difficult is it to get EB-5 visa once you have the funds available to invest? Also, what's the timeline for approval?
Yeah, so that's a great question to bring up. So easy or difficult to get EB-5 is depending really on the nature of the business that you're proposing for the EB-5 visa, basically. So EB-5 has specific requirements that it's not just that you're investing into the business, but you know the nature. And there's also two things to discuss, which is if it's a regional center project or if it's a direct investment. So you know, I do a lot of EB-5 conversations with individuals that want to discuss, and we have filed here at our office EB-5 for direct investment and discuss regional investment as well. So it depends on really on the project. If it's a regional center project, that means it's a project that's already been set up. So everything has already been approved for the project itself with USCIS. So then USCIS is really just verifying your investment, how the investment came, who gave you the investment money, if it was gifted, loaned, whatever it is, we trace everything on that source of funds. If it's a direct investment, then it becomes a very different conversation because direct investment basically means that you're starting a business yourself and you're going to manage and lead the business. So then we have to discuss specifically the nature of the business, how is it going to grow, how's it going to create jobs, where are you investing into, so it's a whole business plan proposal with the case, and then of course we trace your funds and everything like that. So it's a very detailed process. So you want to make sure you're really speaking to somebody that knows the whole EB-5 requirements specifically. But once you know, of course, you get that it's a good project, then you're able to then you know, file for the EB-5. If you're in a project that qualifies for ability to file green card right away, that's great because you have the added benefit of the pending green card application and also the employment authorization and the advance parole document. But if it's a project that's not current, which basically means that it doesn't allow for the AOS filing, then it's a little bit of a conversation because then you may need to wait some time, basically. That basically means you have to maintain your status. So timeline wise, though, the processing time, it varies. The inconvenient part for EP5 is that the processing times aren't really posted. They have like the legacy system, which is years back. They say what the processing time are for old cases when before there was a change on the investment amount in 2022. So they really don't update, but regional centers are usually a little bit of a quicker turnaround. Direct investment take a little bit more time. But again, you know, if that whoever had that question, if they want to reach out to me, I could individualize, speak with them and kind of tell them what we would be looking at if they were to file. The big thing with EB5 right now, if anybody is interested on regional, there is the reauthorization of EB5 that has to happen by next year. And so if anybody files before this year of September 2026, they are grandfathered in. For regional, direct investment does not have that restriction. So it's very important if you are thinking about EB5 to have that discussion soon, especially if it's regional center project.
Jocelyn, yeah, there is an alphabet soup of visas available. So if you guys want to know more about them or have questions about what the options are, feel free to connect with us anytime. I'm happy to guide you. We've been doing this for 40 years now, so we've seen it all. Always happy to help. Lakshman, I will pass it on to you. Looks like we don't have any more questions for now. Thank you.
Wonderful. Thank you so much, Jocelyn and Ariana. Great Q&A, and I think so much, useful information here for many of us. So thank you again. I do want to take a moment to also thank all the speakers. So Pramod, wonderful job in hosting the moderated Q&A, and also again, thanks to Jocelyn for answering all those questions. Really, really wonderful session. Um, I will say, I mean, one thing that I will add for many of the people here is, be wary about information in social media or online, especially through search and the AI tools, right? There's so much information out there, and you have to be really careful with what is being put out there. So there is a lot at risk. So highly recommend that you consult a professional like Chugh Farm and Jocelyn and Ariana are here to help. So please reach out to them and they should be able to help you with your unique situation. So, that's a great investment for your own, safety and security. So please go ahead and do that. Um, Now, with that, we will go back to our promotion for the IIT 2026. Unfortunately, we didn't make it to the 10 count we needed for today's promotion. But no worries. We will continue to, extend this. So what I'm going to do is put my email in the chat. So for those who raise their hand, and for still people who are thinking, so please send me an email, and we will work towards getting you that promotion and discount going forward. So thank you again, and I will hand it over to Dhanashree.
Thank you so much, Lakshman. And thank you so much for Jocelyn, Ariana, Pramod, and Lakshman for the great event. I want to thank everybody who joined today. And one thing, in the follow-up email, you will receive Chuk Firm's information. So if you have any additional questions that you didn't get a chance to ask, you would be able to do that. And we really thank Jocelyn and Ariana for giving us, the opportunity to have answers to all of these questions, which are bubbling in our minds. So thank you so much, and a huge thank you to all the volunteers who are working in behind the scenes and making all these processes run smoothly. We couldn't do this without you. Now, for the next set of events, we have an exciting lineup ahead. So we have Golf Webcast episode 2 on March 7th, which will feature a golf champion's dad sharing how he trained his child to become a top championship player. After that, we have a three-part AI series with Microsoft's former CTO covering agentic AI, MCP, and vibe coding. And after that, we have in-person Holi celebration in San Diego on March 21st. So join us for celebration and meet a lot of people who are part of this community. All of these events are available at iitsocal.org. So we hope you to see not in one of these, but all of these. So thank you so much and have a wonderful weekend. And thank you so much for joining.
Thank you.
Thank you, everyone.